We're good to go. Okay. Good afternoon. This is the committee meeting for Rehab and Social Services. I'm State Senator Barbara Favola. Thank you for joining us, members of the public, and thank you, colleagues, for coming on to your committee meeting. I will ask the clerk to go ahead and call the roll.
Senator Hanger.
Here.
Senator Locke. Senator McDougal. Senator
Here.
Reeves. Oh, Senator McDougal, got you.
Here.
Senator Reeves. Senator Chafin.
Here.
Senator Cosgrove. Senator Serville. Senator DeSteff. Senator McPike.
Here.
Senator Sproul.
Here.
Senator Mason.
Here.
Senator Boysko.
Here.
Senator Morrissey.
Here.
Senator Kiggins.
Here.
Senator Favola.
Here.
Madam Chair, you have a quorum.
Thank you. Just so we have a game plan for this afternoon, we will be hearing three bills, and I would like to take them in the order that is the lowest number to the highest number, but I'm not sure our patrons are available. So I will ask the clerk, do we have Senator Obenshain or Senator Donovan?
Yes, ma'am. Senator Obenshain is on.
Okay. All right. The first bill we will hear then is Senator Obenshain's bill, and that is Bill 5050. We have one speaker on that bill. Senator Obenshain, please go ahead and present your bill.
Senator Favola, this is McDougal. Before you go into that, are we anticipating voting on each of these bills today? Because I have some concerns and objection about voting not in person electronically on the bill. So I didn't want to just voice that up front.
I was expecting to vote today through a roll call vote, which would be, of course, live streamed and recorded. My expectation is every part of this meeting does in fact meet our transparency requirements. But I will go ahead and ask staff if they would like to comment on your comment. Hobie or David?
Unless David wants to speak, I wouldn't say anything other than Finance met this morning and did vote on a bill via Zoom.
Did or did not?
Did.
They did.
Did. Thank you.
Yes, sir.
David, do you have anything you'd like to add? David May?
No. Madam Chair, no, I don't have anything to add. I think a couple of members do have concern, but here we are.
Okay, this does seem to be the safest venue for holding meetings and doing our business, and it's safer for the general public as well. Okay, having said all that, I'm going to go ahead and ask Senator Obenshain to present his bill.
Senator Favola, thank you. And this, I don't want you to think this is a reflection of you or your chairmanship of the committee. It's an overarching concern, not just about the bills in this committee or this committee, but actually voting. And it's certainly one I've expressed historically. I think it is very concerning, and I do have an objection to us voting on legislation that impacts the Commonwealth not in person, and I want to make sure I voice that for these three bills that were taken up, and just note my objection for the record.
Thank you, Senator McDougal. I appreciate your comments, and your objection will be so noted. I understand. Okay, Senator Obenshain.
Madam Chairman, members of the committee, it's good to be with you again. And I have Senate Bill 5050, and of course, everybody on this in this meeting is well aware of some of the events that have occurred over the past several months relating to the Virginia Parole Board. And this bill really doesn't go to the merits of some of the concerns. This is a bill that addresses, I guess, some of the procedural issues in order to provide some increased transparency and to clarify some of the obligations of the parole board. It does not affect who is eligible for parole. It does not impact the merits of decisions that are made by the parole board. It simply clarifies and increases the transparency. It does a number of things.
Senator Obenshain, may I stop you for a moment? I've heard from a member of the general public that somehow the audio version of our meeting is not being relayed in a manner that people can hear. So I think our business is very important, so I do want the public to be able to hear and understand what we're doing and what the debate is, what the deliberation is.
Senator, I'm checking online. I can hear. I will check with our IT department.
Go ahead and check with
But online, I'm listening to the meeting, 30-second delay, and I can hear everything, but hang on.
Okay.
Hobie, same here. And I see our closed caption is running.
So, Madam Chair, I'm not sure.
Okay, you feel that we're safe to go? We're good to go?
It is. Yes, ma'am.
Okay. All right. I apologize for the interruption, Senator Obenshain, and other people are saying they can now hear.
Okay.
So,
no problem. What this bill does, and I'll walk through the bill first on the first page on lines 27 through 33. It addresses the notice that is to be given to the Commonwealth's attorney in the event that somebody is to be released from prison. It clarifies that prior to release, the chairman of the parole board shall certify compliance with the provisions of this section, which requires a notice of 21 days prior to release of anybody who's been sentenced to more than 10 years in prison. Again, it doesn't change the notice requirement. It does not change who is eligible. It simply makes it clear, adds to the checklist, I guess, a requirement that certification be made that this provision has been complied with. Go down to lines 49 through 53. This deals with the information that is made available to the public on the website of the parole board. And if you look at the parole board's website, it has a page dealing with parole decisions. And if you look at each of the months, the decisions that are made during each month, it lists with respect to each prisoner upon whom they take action, the variety of information, including their name, the type of parole, the decision date, whether it's granted or denied. But one thing that has become apparent to me during the course of the past few months is that more information is better. And I doubt that anybody in the media or any civil libertarian would disagree with that proposition. And while this requires the parole board to give the reasons why parole is denied, there is no similar requirement that reasons for granting parole be listed. Likewise, there is no information contained on here about the jurisdiction where the person was sentenced, the sentence that they've served. I know that Senator Morrissey has, on multiple occasions, pointed out the length of time that, for example, Vincent Martin had served. I would submit that this may be very helpful to people like Senator Morrissey or others who wish to make it clear that somebody has served 40 years, 45 years of their sentence. And it would also require the listing of the offenses for which the person was incarcerated. One other area in which there seems to have been considerable misunderstanding by the parole board is how to contact victims or victims' families in the event that they are considering parole. On paragraphs, on line 68 or 67 through 69, it simply adds a requirement that in addition to trying the good faith effort to send notification to the victim, that also notification be sent to the victim witness coordinator in the jurisdiction where the crime was committed. Some of these cases that have been high profile around the state over the past several months have had finger pointing by the parole board and the Commonwealth's attorney about whether the family could or could not be found if they were simply required to also send notification to the victim witness coordinator in the locality where the conviction occurred. It would have prevented, I submit, a good deal of the back and forth that's occurred over the past several months, because there have been multiple instances in which the victim witness coordinator or the Commonwealth's attorney said, if you just asked us, we would have found them. We knew where they were. The parole board said we didn't know where they were. So that is intended to assist in making sure that victims receive notification. And then finally, on lines 132 through 134, requires a certificate of compliance before the release of each prisoner. Now, the service on the parole board is, it's an important job. We pay an awful lot of money to parole board members. The chair's paid $131,000 a year. Members are paid $118,000 a year. And one thing that I left out of my presentation is that the website, well, the law requires monthly publication of statements of action that have been taken by the parole board. The website, however, is woefully behind. The listings currently on the website list action only through the month of June, and all they put up is a spreadsheet each month. I mean, it's not a terribly complicated process, but this simply requires publication of that spreadsheet by the last day of the month, of each month, so that we don't get 30, 60, or 90 days behind like we have during early months of this year, and it looks like we still are running way, way behind. So that's the bill.
Thank you, Senator Obenshain. I do have one question, and then I'm going to ask my colleagues if they have any informational questions before we go to our speaker. On line 135, there's actual repeal of the code section 53.1-154.1. And I'm curious as to why that repeal is in your bill. I checked that section and it removes the director's authority to make recommendations to the parole board. So I don't know why that would necessarily be a piece of your bill, because I at first understood your bill to really be more of a transparency bill. I'm a little confused about line 135.
Oh, that's the intention, is for it to be a transparency bill and also to empower the board. And so if that makes you feel more comfortable, I certainly wouldn't have any objection to changing that, but the board ought to be making those determinations, not the director.
It would make me more comfortable to not remove the authority of the director. So I'll see what my colleagues think. If you're open to that amendment.
Madam Chair, I move that we strike line 135.
Motion has been made to strike line 135 by Senator McPike. Is the second was by Senator Locke. All those in favor of the amendment, please signify by saying aye.
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 Okay, so the chair hears an overwhelming agreement to strike that line. And thank you, Senator Obenshain, for your...
Madam Chairman, could you ask for the individuals who would like to vote no?
I will. I was going to note that you would want to be noted on record, but I will ask for a roll call vote on this. Will the clerk please call the roll on the amendment to strike line 135 in Senator Obenshain's bill?
Senator Hanger.
Aye.
Senator Locke.
Aye.
Senator McDougall.
No.
Senator Reeves.
No.
Senator Chafin.
No.
Senator Cosgrove. Senator Serville.
Aye.
Senator Distaff.
No, and I'd like to explain my no on that. Okay. I believe that this helps gut the bill, and that's not what we're trying to do here.
Senator McPike.
Aye.
Senator Spruill.
Aye.
Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Morrissey.
Aye.
Senator Kiggins.
No.
Senator Favola.
Aye. Okay.
9 ayes, 5 nays.
The bill is before us as amended, and I am going to now call the speaker. I have Beth McClellan.
Madam Chairman, can the committee ask questions of the patron?
May we first hear, I only have one speaker. We can hear from Ms. McClellan, and then we can ask questions. Ms. McClellan, are you in the queue?
I am here. Can you hear me?
I can. You are now on, so please give us your comments.
Yes, thank you, committee members, for allowing me to speak. My name is Beth McClellan of Springfield, Virginia, and I'm speaking in favor of SB 5050. I have read with dismay the news accounts of the parole board's actions this spring with regard to releasing violent felons from our state prison. Equally dismaying is the realization that the parole board can do such things as this in secrecy and without censure. Since the parole board cannot be held accountable for violating the current statutes regarding notifications to victims, local jurisdictions, Commonwealth attorneys, and victim witness program, the very least we can do is require a statement of oath that they did follow the rules set in place. I feel that the provision for the parole board to notify the victim witness program of an impending inmate release is imperative. As family of a murder victim, I and my family are in touch with the victim witness program annually. If there was an issue with the parole board contacting any of us, we are confident that the victim witness advocate would do so immediately and successfully. This is a simple step to help guard against the parole board sending information to the wrong address, phone number, or email address. Please remember how important victim notification is in this process. A victim of violent crime, such as rape or violent assault, needs to know as soon as possible that his or her assailant is about to be released from prison, as the person may need to find resources to deal with such news. Thank you for your time, and please support SB 5050.
Thank you, Ms. McClellan, for sharing your personal story. We really appreciate you being with us, and my heart goes out to you. So thank you.
Madam Chair?
The debate is now with the committee. I first asked Senator Servell because I had put him on hold, and then Senator Morrissey. Senator Servell.
Madam Chairman, I have a few questions. I have a question for the patron, first of all. Senator Obenchain, first of all, with regard to this certification under oath, can you describe for me any other agency of our Commonwealth that we require them to certify under oath, subject to felony penalties, that they're actually complying with the laws we pass?
No, I haven't done a survey.
Okay. Further question, Madam Chair?
Senator Servell.
I saw in part of this, you have, I think it's in line on the release date. I think you have some kind of certification of compliance. Some of the dates that you require compliance with, I think, are a function of the release date.
Mm-hmm.
And
I'm having a hard time hearing you.
Let me try and some of the certifications that you require in here are a function of the release date. And I believe the release date is set by the Department of Corrections, not by the parole board. So are you suggesting that the parole board should be accountable for things that aren't subject to their control?
Now, look, if you look at line 27, that's the first example of a deadline being tied to the release date, and that's current law. It requires notification at least 21 days prior to release on parole. This doesn't, to the best of my knowledge, this doesn't change the date for any of those certifications or notifications. It just clarifies what notice and to whom the notice is to be provided.
Further question, Madam Chair?
Senator Servell.
Right, but given that the parole board doesn't determine the date somebody's released, they only determine whether somebody's released. It seems to me that you want them to certify it as something they don't control. Is that right?
They actually do control. I mean, they can hold up the release, and they can make certain that somebody is not released until more than 21 days after the notice is provided. They have absolutely control over that, as is evidenced by the Vincent Martin case. They held up his release in part, at least according to their response to the Inspector General's report, because they had not provided the required 21 days notice to the Commonwealth's attorney. And as Senator Morrissey aptly pointed out, they actually, in the end, wound up complying with that because they held up the release. The original release date was less than 21 days.
Madam Chair, one more question.
Senator Servell.
Thank you. I think actually they called the Department of Corrections and got the Department of Corrections to alter the release date. I think it was the Department of Corrections decision, not theirs. They just put in a request. But
remember, I'm not changing that. I mean, that's existing law.
Okay. But my other question,
Senator Servell,
is, and I don't really know the way. I'm not really totally familiar with the way the parole board operates. But you have here, you talk about them considering people for release, and considering isn't really a legal term of art that I'm aware of. And so can you highlight for me exactly what considering somebody is for release? I mean, is that like, if I wrote them a letter and said, hey, parole board, I'd like you to consider Joe Smith, and they just say no, and they don't even have a hearing or anything about it, whether that counts as considering, or whether there's like a hearing that takes place, or I don't understand what considering is for purposes of creating potential felony prosecution for these people.
So can you point to any place where I've put in considering? I mean, I think that's already in you're talking about existing law.
Yeah, I am. It's on line 50.
Right.
Because they have to list the name of each prisoner considered. but then you're creating felony. What worries me is you're creating a potential felony prosecution of every member of the parole board if they certify to this stuff. And so, as you know, felonies, I mean, we have to define things pretty clearly when we go there. And I'm just trying to understand what that means.
Yeah, and I guess what I would suggest is that it's not defined apparently clearly enough for the parole board. They're not complying with this under the current laws, and it is, I've heard from hundreds of people over the course of the past several months that we need to make it more clear, and that's what this is endeavoring to do, is to spell out with great clarity what their obligation is. And, this is really fundamental to the safety of our communities. This is an enormous responsibility that we are placing in the hands of 5 people. And if they make a mistake, it is something that has the potential to have serious adverse public safety impacts upon communities across Virginia. So I do think that if we're going to pay somebody $118,000 or $131,000 a year to make these decisions, that they ought to be able to make those certifications and comply with the requirements of this pretty simple 2.5-page statutory scheme.
Thank you, Senator Obenshain. Okay, Senator Morrissey.
My first, I have a few questions of the patron, but I want to ask Ms. McClelland if she's still there. Is she enrolled in VINE, V-I-N-E?
Ms. McClellan, if you happen to be in the chat room, would you mind responding to that question?
Yes, sir, I am enrolled.
Okay. And for the members of the panel, VINE, of course, is the victim information and notification every day. All right, a couple of questions for Senator Obenshain, Madam Chair.
Yes.
Senator, the question that Senator Servo was getting at was the following. The parole board may decide to grant somebody parole, but they notify DOC. Then DOC does what they call advance the release date. And if they do that, the board may have given the required 21-day notice to the Commonwealth's attorney, but DOC advances the release date, thereby preventing, and the chair doesn't know that, they then would be certifying something under oath that they were not aware of. Did you take that into consideration?
Well, as a former prosecutor and as a skilled defense attorney, you certainly would be in a strong position in defending that case if a Commonwealth's attorney were to have brought charges as a result of a certification that was accurate at the time and upon the belief of the makers of that certification. If the date was changed without their notice or knowledge, I can't imagine a prosecutor in Virginia bringing that charge. B, I can't imagine somebody being convicted of that charge. So I think it's an absolute defense.
Okay. Madam Chair, my next question deals with the publication on the last day of the month. You have suggested in the bill that parole prisoners be published on the last day of the month. Right now, grant decisions are currently posted the last day of the following month, and it's done in order to ensure that the victims and the Commonwealth Attorney's Office are properly notified. This legislative change could potentially result in the following scenario: that the victim finds out on a notification or on the internet, as opposed to being notified by parole board. Sometimes it takes several days, maybe a few weeks, to actually talk with the victim regarding a grant vote. Did you consider that in your in drafting the legislation?
Let me give you a couple of responses. Number one, if it were only true that it was published by the last day of the following month, right now, The last disclosure that is published are the June disclosures. If, as you suggest, Senator Morrissey, they were publishing it by the last day of the following month, we'd have July by now. We would have. I would also suggest that or more notice is better, and quite frankly, the sooner we can get notice to families, the better. And quite frankly, if the parole board and the victim witness coordinators can't get notice to victims who they presumably already have information for immediately upon a decision, something's the matter. Our ability to communicate, as is evidenced by this meeting here today, is pretty advanced right now. There is very little limit upon the ability of the parole board, its staff, Department of Corrections to just push send on an email and email the family immediately upon making a decision. And so, I don't think that that's too much of a burden to put on the parole board. They have been so slow and so delinquent in putting these notices out that over the course of the past several months, families who haven't been notified in advance of impending releases of violent felons who've committed felonies against them or their families are finding out 30, 60, 90 days after the release. So this is, really as much as anything, a safeguard. It's something to provide members of the community with more information and the media with more information. So I think more disclosure is good. I don't hear very often people arguing that less disclosure is good.
Final question, Madam Chair, and thank you, Senator Obenshain. Final question deals with the notification of the Commonwealth Attorney and the Victim Witness Coordinator. I think most people on the committee know that the Victim Witness Coordinator works hand in glove with the Commonwealth Attorney in the same office. Do you not think it redundant that it is your legislation makes it incumbent upon the parole board to notify both the Commonwealth's attorney and the individual under his or her employ, the Victim Witness Coordinator?
No, I really don't, because there are two purposes. On lines 31, 32, this is lines 27 through 33. This is the notification to the Commonwealth's attorney that somebody's going to be released. That is existing law. It is not prior to a decision being made. It's prior to a release. The language over on, lines 67 through 69 is the notice to the Victim Witness Coordinator, which is intended for a wholly different purpose. It's to provide an additional means of just trying to make sure before a decision is made that somebody notifies the victim or the victim's family. And as I mentioned before, there's a lot of finger pointing between the parole board and Commonwealth's attorneys. And this simply provides that if the Victim Witness Coordinator knows where the family is, parole board doesn't, that at least the Victim Witness Coordinator is going to get notice and hopefully tell the family. So we're not going to have that kind of finger pointing and recriminations between local prosecutors and the Virginia Parole Board.
Follow-up question and last question, Madam Chair.
Senator Morrissey.
Senator Obenshain, here's a suggestion. Wouldn't it be better to have the obligation for the Commonwealth Attorney to make sure that the victims are registered in VINE? The acronym stands for Victim Information and Notification Every Day. Often it's a situation that the parole board is trying to locate a victim 20, 30, or 40 years later. They don't know where to start. But if the victim were registered in VINE, as Ms. McClelland is, then they know at least where to start. As opposed to sometimes the parole board starting at scratch and trying to locate Mr. or Mrs. Smith, who were the victims from 2 or 3 or 4 decades ago?
Well, most of the decisions that have been made have involved crimes that have been committed 2 or 3 or 4 decades ago, even before Vine was created. So what you're suggesting, I think, is great. I think that going forward, it's important for victims to be enrolled in Vine, but I don't think we can apply a retroactive requirement upon local prosecutors to go back 40 years and seek the enrollment of people who were victimized 40 years ago in Vine. Many of these crimes for which these parolees, controversial parolees, have been granted have been crimes that have been committed in rural communities. The parole board may not have any familiarity with those rural communities, may legitimately have lost track and may not have found these victims or victims' families, but the victim witness coordinator in a prosecutor's office in Nelson County or Halifax County or even Suffolk is probably going to have a lot more success, or may have a lot more success. I don't want to relieve the parole board of its obligations under Vine. I'd love to encourage more people to register under Vine, but I don't think we can retroactively require it.
All right. Thank you, Madam Chair.
Thank you, colleagues. We do have a speaker who just signed up late, I believe a family member related to the McClellan clan. I am going to ask Sarah McClellan if you would like to speak. You're in the chat room right now. You're welcome to make some remarks.
You guys hear me okay?
Yes.
I'm here today to speak in support of SB 5050. The reason I have been able to live my life as fully as I have is because the serial killer that raped and murdered my sister and 4 other women is behind bars. How would I be able to feel safe in my community knowing that this monster, who has never expressed remorse, was free to roam the streets to kill again? Not only would I not be safe, neither would any woman, because this particular perpetrator killed for pleasure and surely will do so again if released. It is our duty as homicide co-victims to advocate for his continued incarceration, to do our part to protect the community at large. How would we be able to do this if not informed of any decision that is made regarding his release? Please mandate the parole board to notify victim witness advocates prior to any decision involving the release of a violent felon, especially one involving the rape or murder of the victim. We have been talking to the parole board every year since 1997. Having the ability to provide input into their decision has been extremely important for us. Having to advocate yearly and now twice per year due to the condition of geriatric release is extremely painful and devastating. But at least our input is considered. I cannot imagine any violent perpetrator being released for any reason without victim notification and input. The nature and the circumstances of the crime should absolutely be paramount in these decisions, and who better to shed light on those than the family of the victim. My best friend, Melanie Shepard Little, was murdered at point blank range. He confessed to this. He shot her 6 times. Words cannot describe this loss. Melanie was a dedicated mental health therapist who loved butterflies and helping people. She and my sister were 2 of the most gentle and kindest people I have ever known. That case is still pending, and the charge is murder too. During recess at the preliminary hearing, this man turned and stared me down in the courtroom for what felt like a prolonged period of time. Should he be convicted of the crime to which he confessed, and if sentenced in the future, I'm going to need to know if and when he is to be released, as I will be in fear for my safety. The only reason I am able to have peace at the moment is knowing that these 2 killers are incarcerated and not a threat to me, my family, my community at the moment. As you vote on this bill, please consider the impact your decisions will have on the victims of violent crime and their families. It is re-traumatizing to think about our loved ones' perpetrators being released. It is even worse to think that this could occur without notice. Please vote in support of Senate Bill 5050. Thank you.
Thank you, Ms. McClellan, for sharing your thoughts. Again, we extend our gratitude for your courage. So thank you.
Madam Chairman?
Yes, Senator.
It's Monty. Thank you. May I ask maybe one or two questions?
Sure.
based on what Senator Marcy was just asking about the reporting, Senator Obenchain, I'm looking at the spreadsheet and it looks current through the end of June. Senator Marcy said that that would mean that that was the end of the July report reporting back to June. So this would seem to be current based on that. And he mentioned notification timelines. Is it your intent to change that, or would that remain the same just with the addition of some additional data points?
Thank you very much. What the law provides is publish monthly a statement regarding the action taken by the parole board on the parole of prisoners. I think that that is intended to require publication by the end of the month about the actions taken during that month. And this is really intended to clarify that. I don't believe that it changes existing law. I believe that the parole board is far behind in its obligation to provide notice.
Okay. Colleague, do you have any further amendments you would like to make to this bill, or do you feel comfortable offering a motion at this time?
Madam Chair?
Senator Hanger.
Yes, I think, you know, there was an amendment that took a section out that had merit, but I think that may be a subject for another bill. It's now a transparency bill, and I move that it be reported.
Okay, the motion has been made to report. Where is the second? Senator Reeves. Okay, a motion has been made and seconded. Will the clerk please call the roll?
Senator Hanger.
Aye.
Senator Locke.
No.
Senator McDougall.
Aye, but renewing my objection that the votes be held in public and in person.
Senator Reeves.
Aye.
Senator Chafin.
Aye.
Senator Cosgrove. Senator Serville.
No.
Senator DeSteph.
Aye. However, I like the original bill much better before we gutted it.
Senator McPike.
Aye.
Senator Spruill.
No.
Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Morrissey.
No.
Senator Kiggins.
Aye.
Senator Favola.
Aye.
Ten yeas, 4 nays.
Chairman, members of the committee, thank you very much.
The bill reports. Thank you, Senator Obenchain. Regarding Senator McDougall's comment about the need to ensure we have complete transparency on the committee, there is an Attorney General's opinion. I'm sure you're aware of this. And he concludes that if the nature of the declared emergency makes it impractical or unsafe for the public body or governing board to assemble in a single location, or if the purpose of the meeting is to discuss or transact business that is statutorily required, a public body shall make available a recording or transcript of the meeting on its website, and in fact may be able to use these technology tools that are at our disposal. I have perhaps very quickly summarized the opinion. So there is that opinion there.
Madam Chairman, I just specifically in response to that,
yes.
Certainly the first item is if it's impractical. We have been meeting in person for multiple days and we'll be doing so ostensibly this week for multiple days. So that is the reason for my objection. It is not impractical for us to meet in person. So again, that's not a reflection of your leadership whatsoever, but that's the reason for my objection is we can meet in person. We have been meeting in person. We're going to meet in person again, and thus all votes should be in person.
I understand. I do appreciate, though, the fact that in the middle of a pandemic, we should probably meet much less in person. There are studies that show a lot of togetherness is not so good in these situations. But thank you for your comment. Let's move on, colleagues, to our next bill, which is Senator Donovan's bill. It's item 5096. And Senator Donovan, are you in the queue? I'd like you to present your bill.
Yes, ma'am, Madam Chairman. Can you hear me?
Yes.
Very well. Madam Chairman, this bill is very similar to a bill that has already passed through Education and Health. Is on the floor of the Senate. It's essentially designating that child care providers will become identified as essential workers to increase their availability to PPE. We have an enormous number of child care centers that are stepping up to be a safe place for children to be while schools are closed. And one of their biggest challenges as small businesses is being able to get access to PPE so they can ensure a safe environment for the teachers and the children. It does not have a fiscal impact. And with that, Madam Chairman, I'm happy to answer questions.
Thank you, Senator Donovan. I have one technical question. Perhaps staff can respond. On line 18, it says any group afforded priority. My question is, which group, who would be affording the priority? Is it the state of Virginia or another body?
It can be very different circumstances, but certainly the Virginia Department of Health has had access to make sure that they can purchase at a reasonable rate PPE and make it available to essential workers throughout Virginia. But also there are collaboratives that get together to purchase PPE. So it's just a matter of giving them standing, Madam Chairman. We've had problems with this throughout COVID. We had, for instance, private ambulance drivers that were not included in the list of essential workers, and they were doing an enormous number of transports, and we just had to get them realigned to make sure that they were included in that list. And this does very much the same thing for childcare workers.
So any list that happens to be out there, essentially, either an association
any
list,
collaborative that's put together. Yes, ma'am. Exactly.
Okay, that helps me. Colleagues, do you have any questions of our patron? And we have one speaker.
One question.
Senator Morrissey.
Senator Donovan. Senator Donovan.
Yes, sir.
I really like this bill. I got a question. You're on the line 17. It says a child daycare center. Would that include a preschool like Goddard or Montessori, which, as you know, is really a combination of schooling and daycare?
Thank you, Madam Chairman and Senator Morrissey. Thank you, Madam Chairman and Senator Morrissey. I think that between these two bills, one of the bills addresses private schools, Senator Morrissey, and this one addresses child care centers. And so I think between those two arches, we have identified all of those services that are stepping up to expand capacity to take care of kids. So I believe between one or the other, my intention is that all are included.
Okay, thank you, Senator Donovan. Are there any other questions, colleagues? Hearing none, let's move to our speaker, Emily Griffey. Are you still in the chat room?
I am here. Thank you, Senator Papola.
Welcome.
And thank you, Senator Donovan, for introducing this bill. I know that many child care providers were very excited to see the words essential worker included with their position, and I appreciate this recognition of the essential role that they play. I want to speak quickly to the child care workforce, which you know is majority female and disproportionately women of color. They're paid much less than their counterparts in public education settings, and this is during the most critical period of brain growth and development. The childcare industry as a whole is struggling right now. To implement safety measures, they're using lower group sizes, which means less tuition, as well as increased costs of providing care to ensure that it's safe and to keep facilities clean. The governor has proposed some funding for childcare, but will know that there will take more to ensure stability for the sector. In fact, over a third of childcare programs have indicated that they may not make it an additional 6 months without additional financial support. This measure helps to appreciate the role of the childcare sector and the committed role that they have in playing to ensure that children are safe, healthy, and learning in this time. So thank you for bringing this bill.
Thank you. Okay.
Madam Chairman, if I may just follow up on that comment. I just want to say the child care workforce for us has done a most extraordinary job during this pandemic. 60% of our child care centers have stayed open, and they have done everything necessary to protect those families and those children. In all that time, in all those children, in all those centers, there's been one outbreak and no hospitalizations. They are a role model for what we can do in schools. And they are a vastly underappreciated workforce. And all of our essential workers, the nurses that went to work every day, all of the people that protected our supply chain and our grocery stores, they could not have been at work if these essential workers had not been there for their children. So I do want to celebrate them and thank them for the work that they've done and they continue to do, because their work is so much larger now that we have so many kids that are trying to figure out where to be.
Thank you, Senator Donovan. Yes, our child care centers have been doing yeoman's work, and they are very needed. Many workers have to return to a workplace. They cannot work remotely, and child care is a necessity for our families and for our businesses. Colleagues, the bill is before us.
Move report.
Second.
It's been made by Senator Mason, and who is my seconder?
I'll second.
Okay, Senator Boysko. Oh, okay. Will the clerk please call the roll?
Senator Hanger.
Aye.
Senator Locke.
Aye.
Senator McDougal.
Aye, but renewing the objection of in person.
Senator Reeves.
Aye.
Senator Chafin.
Aye.
Senator Serval.
Aye.
Senator DeSteff.
Aye.
Senator McPike.
Aye.
Senator Spruill.
Aye.
Senator Mason. Senator Mason.
Oh, aye.
Thank you. Senator Boysko.
Aye.
Senator Morrissey.
A strong aye.
Senator Kiggins.
Aye.
Senator Favola.
Aye.
Ayes 14, no 0.
Okay, Senator Donovan, your bill reports.
Thank you, Madam Chairman, members of the committee.
You're most welcome. The next bill is Senate Bill 5103, and that is Senator Chafin's bill. It has to do with the eligibility for parole. Is Senator Chafin still on our call here?
I'm right here, Madam Chair.
Okay, very good. Senator Chafin, please present your bill, and I only have one speaker on your bill.
Yes, thank you very much. So like many of our bills, this bill has a story behind it. And the story involved a young lady named Gina Hall, who was a freshman at Radford University in 1980. And that is where she met her murderer, Stephen Epperly. The case is a rather famous case. When I attended law school in the early 80s, the case was making its rounds through the Supreme Court. It is a Supreme Court decision, and it was the first case where an individual was convicted of murder without the corpus delicti, or the body of the crime. There was no body ever recovered. Unfortunately, Ms. Hall's body was never found. We call the bill Gina's bill, and fitting as it may be, today is her birthday. And if Gina were here with us, she would be 59 years of age today. So her murderer killed her and refused to disclose the location of her remains. This bill would make an offender convicted of murder not eligible for parole in cases where the victim's body has never been located, and in the case where the parole board has reason to believe that the offender has information concerning the location of the body. So that's pretty much the bill right there. And I'll be glad to answer any questions.
Thank you,
I
Senator.
got a question.
Colleagues, this would be questions for the patron. Senator Morrissey.
Senator Chafin, I was hoping you were going to tell us the back story, and I knew there was one. Question, did the defendant in that case plead guilty or not guilty at his trial?
Madam Chair, Senator Morrissey, he had a full trial. He pled not guilty. There was just a myriad of evidence about that convinced the jury that he was in fact guilty.
Further question.
Senator
Chafin, an individual pleads, and you're a very distinguished and highly regarded attorney, a defendant pleads not guilty and later is convicted by a jury. Do you not feel that this somehow would have either a chilling effect on his initial plea, or more importantly, would impinge upon his post-conviction rights by making him fess up, for lack of a more artful expression, to where the body is, given that he or she has pled not guilty to the underlying offense?
Madam Chair, Senator Morrissey, I would say that this bill recognizes and respects the rights of the victim's family. Members who know who killed their loved one, they know pretty much how their loved one met their end. They generally know the area in which their loved one met their end, because there's all types of blood, trace evidence, those types of things. But they're being denied the closure of knowing where their loved one's remains are, where their loved one's body is. And so it is a matter of fairness and of justice. These individuals know what they have done to secrete the remains of the victim.
Follow-up question.
Senator Morrissey.
Let's assume, arguendo, that there is strong evidence that the defendant who has been convicted and is in jail knows where the body is hidden. By making it incumbent upon the parole board, in the language on line 52 is, has probable cause to believe, all right, does that not, in your opinion, put an onus on the parole board that is more appropriately placed within the bailiwick of the Commonwealth's attorney or the police or law enforcement?
Madam Chair, Senator Morrissey, I would not agree with that proposition. I think that the parole board considers these issues right now. I think they're already considering whether or not a victim's remains have been identified, and in terms of their determination for parole. And so the probable cause, as you know, Senator Morrissey, being a very accomplished trial lawyer, the probable cause hearing or probable cause issue is a rather simple issue involving only reasonable grounds for belief. So the only time that it could ever, in my mind, really come up that there would be a question about probable cause as to whether the killer knew is if you had a situation with multiple killers, and you had there might be a situation where the killers had different roles involved, and one or more might not know the location of the body.
Final question. I'm sorry. Final question, Madam Chair.
Senator Morrissey.
Ben, I'm Senator Chafin. Last question. Do you not see the following situation? This becomes a Christmas tree upon we put other fess up to the crime bills. The thief, the jewelry thief, before you get parole, tell us where the jewels are hidden. The embezzler, before you get paroled, tell us where the money is, and then just create a wildly uncontrollable burden on both the parole board to investigate crimes and suss out confessions of people who they think murdered or stole or embezzled, go on and on and on.
Senator Chafin.
Madam Chair, Senator Morrissey. No, I really don't. I mean, I believe that the legislature would be able to engage in the restraint necessary not to create a Christmas tree here. This bill seeks to recognize simply the victim's rights in the most egregious case possible. And that is the case where some monster has killed your loved one, has denied you the respect and denied the family the respect of telling the family and the authorities where they secreted the remains, what they did to the remains, how did they destroy the remains, how did they keep them from public scrutiny. And those situations are quite rare. They're quite rare. And that's why, you know, I know that I can think of a couple more that are in Virginia, but they're quite rare.
Madam Chair.
Yes, Senator Sproul.
They can't see me. When two lawyers get together and start talking, not only they confuse themselves, they confuse the heck out of me. I'm trying to get back to the bill. My question, the bill states that when a person who pleads not guilty is found guilty, then are you saying that I plead not guilty, but I'm found guilty, you're saying show me the body. The other part is a person who pleads guilty and know where the body is, but would not. So I'm trying to get back to my brother Moss and ask some of the questions. I'm trying to find out what the question is. Your bill is your bill saying a person who pleads guilty for the murder of someone and knows where the body is and does not tell. It is saying a person who pleads not guilty. Then how can they say where the body is when they plead not guilty, even though a jury may have found them guilty, but they plead not guilty? So how can they say where the body is versus a person who pleads guilty and knows where it is?
I think that's a loophole worth noting. Senator Chafin.
Yes, Madam Chair.
Please.
Senator Sproul, this bill applies to both those situations. It applies to the situation where a person is found guilty, whether they actually pled guilty or whether they pled not guilty, but a jury convicted them and it withstood the scrutiny of numerous appeals, which is what this case, which is what happened in this particular case with Mr. Epperly. It's been appealed numerous times and has withstood that scrutiny. He's been in prison for almost 40 years. So that is the type of bill that this is. And so it keeps those individuals from qualifying for parole if they have been convicted of these heinous murders where they have secreted the victim from the family.
But sir,
Senator Sproul.
I'm sorry, thank you, Madam Chair. So my question, just suppose maybe some who pleaded not guilty and know, but what about just so happened that a person who really pleaded not guilty but was found guilty, what happened that person really does not know where a body is, but he didn't do it, but he was still found guilty by his peers. They found him guilty, and he said he did not. What about that person who really that was found guilty, but he or she does not really know? So are you saying so they would not have the opportunity to be rolled for parole, even though I agree that I was found guilty by peers, a group of peers of mine that I really don't know because I didn't do it. I was found guilty. I'm going to accept their penalty. But now you said I can't get out because I have not shown where the body is, and I really do not know. Is that fair, sir?
Senator Chafin.
Madam Chair, yes, I think that is fair. I mean, I do think that is fair. I think it's, Senator Sproul, I think it's fair when you've been convicted of killing someone in a heinous crime and destroyed the body so that you would be able to maybe not be convicted of that offense, not be prosecuted of that offense. That's the reason that people destroy the bodies is to try to pretend like they didn't do anything wrong. And so oftentimes they will say, I didn't do it. because you don't have a body. Ha, ha, ha. You don't have a body. And that's the situation in this case.
Thank you, sir. Thank you.
Okay, colleagues, we have one speaker, and I would like to get to that speaker. It's Diana Bodmer. Diana, are you still in the chat room?
Yes, hi.
Okay, we can now see you. Go ahead and offer your remarks.
Well, thank you, Senator Chafin, for carrying the bill, and the committee members for having me share my 40 years of experience with this issue. My name is Delana Hall Bodmer, and I am the sister to Gina Renee Hall, who was the victim in this case that Ben references, the no confession, no witness, no body conviction that set precedents for all other successful cases and trials that followed for 4 decades. The reality is, as I may respectfully address to others, that anytime we lose a family member to a violent crime, it's a traumatic life event. There is no way to undercut that. And I would ask to think of it as if it were your own family member, anyone who considers any of these types of bills. But when it is a no body ever found conviction, the heartbreaking reality is that my sister's body is buried somewhere out there, hidden from her family in some unknown place, and it might not ever be found. These no body recovered cases also have a domino effect, like a ripple effect, and the murderer himself becomes the focal point, like a pebble in a pond. And he begins to use it himself with the parole board that does make those decisions with their own probable cause and reasoning as to what they do, whether they release or not this person. And the gentleman uses, I wouldn't call him a gentleman, the murderer uses this as a tool to barter. He has for 40 years. And it extends emotional harm to not only the family and friends of Gina, but also the citizens of Virginia that are cognizant of this case. And I think one point to emphasize that is often so many times overlooked is that by doing this, it's creating a continuous cost to the state of Virginia. There are financial implications when these successful convictions are rendered. The case still remains open because it's unsolved. So the state authorities continue every investigation and follow through for decades in my sister's case. And that's the way it should be, so that we can try to bring her home. So he plays the games with everyone. And as long as he thinks he can get parole, he'll rarely disclose the location of those remains, and those games will continue to be played, and the investigative costs will continue to rise for the state. For over 40 years, every 1 to 3 years, I attend a parole hearing, and I plead that Gina's murderer remain imprisoned. And every time we attend these parole hearings, we relive the trauma and the reality that we never brought her home. The search will never end. The families will not stop. The police officers will not stop. The prosecuting attorneys will not stop. And it all centers around that one person. So the implications are much further than just the victim and the victim's families. These no-body convicted murderers are absolutely the absolute worst of the worst. These are the ones who have no remorse. They're master at manipulation. They are capable of hiding bodies and dismembering bodies. Gina's bill would send a message to Virginians that those who represent us would assure that these types of murderers, these no-body convicted murderers that, as Senator Chafin said, went all the way up the ladder through every appeal process, that they forfeit their right to parole when they don't tell where the victim's remains are located. It's a little simple change, but it has such a huge, meaningful impact to that entire process. And yes, Gina's legacy is that we have now gotten convictions throughout the decades and prosecuted many murderers. And yes, it is her 59th birthday. And it's a simple change, but it's a mighty change, just like Gina was and still is today. Thank you for listening to Gina's story.
Thank you, Delana. Thank you for your courage. We appreciate you being here. Okay, colleagues, the bill is before us. Senator Chafin, was this ever discussed?
Madam Chairman, can I ask a question? I've had my hand up for a while.
Oh, yes. Let me just, I have a very quick question, and I'll turn it to you. Was this discussed before the Crime Commission, Senator Chafin?
Madam Chair, no. No, this was not discussed before the Crime Commission that I'm aware of.
Thank you. Senator Servo.
Thank you, Madam Chair. I got a couple questions for council, I think. Council, can you confirm for me that that the decisions of the parole board are not appealable to anybody?
I am not positive. I don't believe that they are.
Right. Madam Chairman, another question for council. So council, given that we are, I guess, altering the terms of I don't know if there's any other no-body defendants out there besides this one particular person, or no-body convicts besides this person. But given that we're altering that person's rights and responsibilities after the fact, and also we're setting up a process by which the parole board can, I guess, deny them liberty based on a probable cause determination without any type of appeal. I mean, do you have any concerns about the constitutionality of this? Because typically the hallmarks of due process are the right to notice, an opportunity for a hearing, and the opportunity for an appeal. And, you know, it would have seemed to me that denying an individual their right effectively to a parole hearing based on a probable cause determination is pretty unique. You aware of any constitutional infirmities around that?
David May.
Did he vanish? Oh, there he is.
Yeah, he's here.
Everybody reoriented there. Okay.
I'm not. I would. I guess I would say I would think that if we had a problem, we probably already have one in that regard. But I don't think it's unfounded to bring up. It is possible. I also think the language maybe is a little bit unclear in that it uses the probable cause standard, but it's probable cause that the person has information. It doesn't say, you know, you have information that you haven't disclosed. So it could be you have information and you told them that could or could not qualify. Maybe you've disclosed part of it. So I'm not sure I think at the very least, you might want to clean up that standard a little bit.
Hey, Madam Chair, one more question.
I think this bill is more complicated than you might think. Senator Servo.
Yeah, so and I noticed in the code that the probable cause standard applies with regard to looking at things like parole violations or probation violations. But I can't find anywhere else in the code where the parole board can make a finding by a standard that's as low as probable cause that affects somebody's rights and responsibilities. I mean, you know, for those of you on the committee who aren't familiar, in the legal world, we have different evidentiary standards, beyond a reasonable doubt being the highest standard in a criminal case, clear and convincing evidence being sort of, say if beyond a reasonable doubt is like 95% true, clear and convincing evidence is like, say, 75%, preponderance of the evidence is like more likely than not, or 51%. Probable cause is like down under 51% somewhere, at least how the courts have looked at it, I think. Is council aware of any other place in the code where the parole board makes determinations by a probable cause standard to determine somebody's rights?
Madam Chair, Senator Sturgill, yeah, I did a search as well, and I couldn't find any instances where they used the probable cause standard.
Okay, thank you.
Okay.
Madam Chair.
Senator Chafin.
Yes, so I would point Senator Serval to all those instances where individuals are convicted, and after they are convicted, when they are on probation or otherwise, they lose a lot of constitutional rights. You know, they give them up, and they don't have to. The probation officers and the people in DOC, they don't have to have probable cause to believe they've committed a crime. They don't have those rights. Okay, they no longer have those rights. But the rights that they do still have are the rights to prove that they didn't commit the offense in the first place by finding new evidence, by coming up with DNA evidence, by coming up with, so there's all kinds of rights that they still will carry with them going forward that we hear about. And that's why we occasionally find someone whose conviction is overturned. This bill would have nothing to do with those individuals. Nothing to do with those individuals. This bill, it would not prevent those individuals from being found not guilty or being set free through some process through the governor's office. This bill would not affect those. This bill simply would affect those individuals who have committed these most heinous of crimes, gone through the entire process, and sat silent about what they did with the body.
Madam Chair Sproul.
Senator Sproul.
Thank you. Madam Chair, the members committee, I'm not voting for this. If I thought that if African Americans were treated like white folks, let me use my term, as far as the Simpson guidelines, I can understand. But because you have had so many African Americans who were found guilty by their peers that did not do such crime, then so I'm already saying I'm not guilty, but I was found guilty. So I'm gonna say the term. And then you saying now, so you got to produce their body. I'm already saying I didn't do it. So how can I produce something that I didn't do, but my peers in court have found me guilty? So right now, so because so many African Americans in the last 30 or 40 years that's been found guilty on crimes that they did not do, then you can add this on top of them. If Virginia was a fair system, as far as judging blacks like to do whites, as far as a case, boy, let's take a simple bill, for example, if a kid was still an apple. A white kid would get, well, he didn't have a mother or father, so you just send him home and give him a spanking. A black kid would do the same thing. You put his time back in jail for how long? So until the system is fair pertaining to an African American versus a white person, so my question, I'm already in jail. I say I didn't do it, but I was found guilty. I'm in jail, and now I can never get out because I cannot produce a body to something that I said I did not do. Until the system in Virginia treats blacks the same as they do whites, I would never vote for something like this. Thank you.
Senator Sproul, is there a motion in your comment?
Madam Chair.
Senator McPike.
Thank you, Madam Chair. Just a question for Patron. First off, I'd like to say I thank the family for speaking today and having the courage to be able to discuss something very painful. And I think that the bill has some laudable goals. The concern or question, looking through some of the logistics to the patron, what happens in my area, for instance, there's been a lot of development in 30 years, right? The individual comes and says, yeah, the body's somewhere in this area. And they don't find the body. Development, roads have changed since I lived in, for instance, Prince William County, tons of roads have changed. Does that person, or they still have no rights or eligibility for parole, even though they've given the information?
Senator Chafin.
Madam Chair, Senator McPike, I would say that the crux of this slight amendment to this statute would be that the information is given. Okay, that there is a willingness, a positive willingness to give the information that that individual has. Okay, now certainly things can happen. wild animals, all kinds of things can happen to remains that have been deposited in some secret location in a secret manner. So the issue is whether or not that information has been returned to the authorities in order to give that individual the possibility, not the promise, but the possibility for parole.
Follow-up question, Madam Chair.
Senator McPike.
I believe in your opening on the bill, you stated that the parole board already considers this somehow. Is that correct? Is that what you stated?
Madam Chair, Senator McPike, I think the parole board considers all factors. They're required to do an investigation each time, and they consider all the factors. And I feel very confident that they consider the fact that the convicted killer has not told anyone what he did in this case with Gina Hall's body.
Okay.
Thank you, Madam Chair.
Thank you.
Madam Chair.
Senator Hanger.
Question for council. David?
Mr. May, are you still on the line?
David, you still there?
David?
I'm here.
Okay.
Go ahead.
You said that it lacked clarity. I was wondering if after information, we added the words not previously disclosed, that would clear it up for what you were speaking to.
Madam Chair, Senator Hanger, I think that would help out a lot. I think the idea here was to make sure that they've disclosed that information. So
okay. Madam Chair, I'll move that amendment.
Okay, motion has been made. Is there a second?
Second, Reeves.
Okay, colleagues, would you prefer a roll call vote on this, or may I do just a general sense of the committee? I will go ahead and do a roll call vote. Motion has been made and seconded. Are you clear on the amendment? We're going to add after information not previously disclosed. Is that correct?
That's correct.
Okay. Will the clerk call the roll, please?
Senator Hanger.
Aye.
Senator Locke.
Aye.
Senator McDougall.
Aye.
Senator Reeves.
Aye.
Senator Chafin.
Aye.
Senator Cosgrove. Senator Servo.
Aye.
Senator DeSteff.
Aye.
Senator McPike.
Aye. And I also like to note McDougall's objection to the electronic vote.
I'm coming with that with the full vote, not on the amendment.
Not on the amendment.
Be patient. Be patient.
Senator Spruill.
Aye.
Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Morrissey.
Aye.
Senator Kiggins.
Aye.
Senator Favola.
Aye.
Ayes 14, no 0.
Okay, so
Madam
Chair.
Amended bill. Senator Morrissey.
I have a question too.
Wait, Senator Morrissey, is your motion or is it a question?
Question.
Okay, Senator Morrissey.
Thank you. Ben, I like the bill I like the spirit of it, but here's what's troubling me. And there's a couple of points. Number one, first of all, I want to thank Mrs. Budmer for coming out and testifying. It reminds me of the law school and the Christian burial speech that the detectives gave to the defendant on the way to the police station. They want a Christian burial for their loved one. I get it. And she is to be applauded for coming forward. Here are my problems, though. Senator Spruill articulated one of them. The individual, the defendant, pled not guilty to the murder. And what we're doing is the following. We are tasking parole board members, some of whom are not lawyers, to determine if there's probable cause to believe, based on information not previously disclosed, that that person does know where the body is. That's troubling to me, putting that onus on those individuals who are not lawyers. The second reason is this. I do not believe there are a bevy of cases out there where the person was convicted of murder without a corpus. But I want to share this little vignette with the members of the body, and I hope you'll appreciate it. I taught law school in Australia for 3 years, and there's a very famous case called the Dingo murder case. Very famous. A couple were with their son, were camping. The husband went off fishing. The mother was left with her child. The child disappeared. There was nobody around at all. And she told detectives the dingoes or a dingo got her baby. Nobody, and it made worldwide news. Nobody believed her. She absolutely did something to that baby. And they wanted to tell her who it was. And she said, I didn't kill my baby. The dingo took the baby. She went to prison for life. 6 years later, in a general area, hikers found a dingo den. And in that dingo den, they found clothing that belonged to the child. And the woman was immediately released. The dingo did take the child. That's my problem here. A not guilty verdict entered by the defendant, and we are now tasking the parole board to determine, does he or does he not know where the body is? I love the spirit of it, Senator Chafin, but it's for those reasons that I'm going to have to vote no.
Colleagues, we can always,
Madam Chair.
if this were to be PBI'd, we can always send a letter to the Crime Commission.
Madam Chair, Senator Reeves.
Senator Reeves.
Question for Senator Chafin. Wouldn't the inverse be true, though, as well, if this is new information that you're trying to get out of the suspect? And wouldn't they be able to tell if there were some elaborations based on the facts of the case, some of those things that just couldn't be made up? And the vice versa would be true in the sense that if they really didn't have any information, were trying to be forthright, and none of it coalesced around what they actually knew the facts and circumstances to be of the case. Couldn't that also point to their freedom in the sense that maybe he is actually wrongly convicted? That would be my question.
Senator Chafin.
Yeah, Madam Chair, Senator Reeves. Yes, I would absolutely agree with that, and I would say in the two scenarios that Senator Morrissey laid out for us. The fact finders in cases are in fact lay individuals. They are jury members, just like the parole board would be fact finders. And I would also say that in the Dingo case, were that similar to this case, the Gina Hall case, or other cases, that's new information that comes out. This has nothing to do with that. With all due respect, has nothing to do with that. That's not going to be a factor in the parole in a parole hearing. That's going to be something that gets the person a new hearing, a new trial, a new something in front of a judge to be released. So, with that having been said, I move to report the bill.
A motion has been made to report. Is there a second? And who is
second?
And Reeves. Okay. Motion is before us, colleagues, to report. I will ask the clerk to call the roll.
A substitute motion.
Substitute motion.
PBI.
Substitute motion to PBI. Is there a second?
Second.
By Senator Morrissey. Okay, we will deal with the substitute motion first. Substitute motion to PBI. Will the clerk please call the roll?
Senator Hanger.
No.
Senator Locke.
Aye.
Senator McDougall.
For Senator McPike, I renew my motion that we not take any of these votes electronically and vote no.
Senator Reeves.
No.
Senator Chafin.
No.
Senator Cosgrove. Senator Servo.
Aye.
Senator D-Step.
No.
Senator McPike.
Aye.
Senator Spruill.
Aye.
Senator Mason.
Aye.
Senator Boysko.
Aye.
Senator Morrissey.
Aye.
Senator Kiggins.
No.
Senator Favola.
Aye.
8-6.
8 ayes, 6 nays.
Okay, the bill is PBI, but I will ask my colleagues if they would agree to allow me to send a letter to the Crime Commission to study this issue. I think there's some real process points as well as important issues related to due process that have come up regarding this bill. So may I ask unanimous consent to send a letter to the Crime Commission and ask them to consider this bill. Do I have that?
Yes.
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 Okay. Anybody objecting to my letter to the Crime Commission? Hearing none. Senator McDougall, I don't think you need to go on record on that vote.
Thank you, Senator Favola.
On that voice vote. I'm watching out for you.
Somebody needs to. I appreciate it.
Trying to keep your record sustained. Okay, colleagues, I believe that concludes our agenda for this afternoon. Is there anything else to come before the body?
Madam Chair?
Yes, Senator Morrissey.
It's not bill related, but I do have a question. First of all, thank you for conducting the meeting. My question is this. We know that the cat in the background belongs to Senator Boysko.
Yes.
We know that the car in the background belongs to Senator Kiggins. We know that the diplomas in the background belong to Thurville. I was just wondering which yacht in the background belongs to DeStef.
Well, Senator DeStef, you do not have to answer that. I'm not sure that's information necessary for the public to understand our deliberations. But anyways.
Jet skis, and they all belong to me. But Madam Chair, I actually have a serious question, and that would be, how do we do proxies via Zoom? Because I know that Senator Cosgrove probably would have wanted to do his proxy today. And I don't think we ever discussed how we do proxies via Zoom. So if you could help me understand that, I would certainly appreciate it.
I will ask staff that question. I would think we want everything documented as we do when we're meeting in person. But I will turn to Mr. May and or Hobie, whoever feels most confident about answering that question.
Madam Chair, I think we need to talk to the Senate clerk about that, but I've been told via Zoom as of now there are no proxies.
Okay, that's the answer for the moment. Okay, colleagues, again, I think we have concluded business. Is that true, Mr. Lehman?
Yes, ma'am.
Okay, having no further business, I move that the committee rise. We're adjourned. Any objections? Hearing none. We're adjourned. Thank you.